So I welcome you all. I'm Varadhi Singh from CUTS, and I'll congratulate to all of you a very happy World Competition Day. It is my pleasure to welcome all the speakers and participants to this timely webinar on this year's themes for the World Competition Day, which is Artificial Intelligence, Consumers, and Competition Policy. Now, CUTS International, CUTS Institute for Regulation and Competition, and COMESA Competition Commission are jointly organizing this event in order to commemorate the World Competition Day, which we celebrate on 5th of December every year. On this date in 1980, the UN General Assembly had adopted the set of multilaterally agreed equitable principles and rules for the control of restrictive business practices, popularly referred to as the UN set. Now, the UN set is the first and so far the only international instrument on competition law and policy, which is a milestone worth celebrating. This is the 16th year that we are celebrating this campaign and advocating for its formal adoption by the United Nations. We have received support from around 65 countries and including 60 competition authorities. Thus, it is a widely celebrated now. Our campaign got revitalized last year when COMESA Competition Commission formally joined this initiative. Some good developments have taken place this year. In July 2025, during the 9th United Nations Conference on Competition and Consumer Protection, a resolution was adopted welcoming the proposal from the government of Kenya for the recognition of 5th December as the World Competition Day. The resolution encourages the member states to pursue consultation on this issue. We feel that in July 2026, further progress will be made during the 23rd session of the Intergovernmental Group of Experts on Competition Law and Policy at UNCTAD. On AI, consumers, and competition policy, the theme of this year's World Competition Day, and also the topic of today's webinar, I can say that this is very timely and important. While AI holds transformative promise, it also presents emerging risks to consumers and market competition. Our policy goal should be to minimize such risk and maximize its gains. I'm sure the panel deliberation today will provide some good insight on this. So the agenda for today's event is like this. After me, I would invite Dr. Willard, Chief Executive Officer of COMESA Competition Commission. She'll make the keynote speech. And after the speech, we will request Dr. Mwemba to do a small ritual to advance release our BINI publication, India Competition and Regulation Report, which we call as ICRR. The theme of this year is Artificial Intelligence, Minimizing Risk and Maximizing Gains. Now, this publication will come out soon, likely within a month's time. After this, I will hand over the mic to Kazim Rizvi, the founding director, dialogue, and the moderator of the panel. To set the background for the panel discussion, my colleague Vidhi Maharshi will first make a short presentation on CCI's market study on artificial intelligence and competition, after which the panel discussion will start. We have a very expert panel lined up today from Africa and India. Odie Strydom, Managing Director, Betweenity from South Africa. Leonard, he's Council Member, ECOWAS Regional Competition Authority. He's joining from Nigeria. Hemangini Dadwal, she is Senior Partner, AZB and Partners. And Mr. Rahul Roy, he's Partner and Co-Founder, Axiom 5 Law Chambers. Both Hemangini and Rahul are from India. We thank you and welcome you all. We also welcome all the participants and encourage you to ask questions to the panelists. You can post your queries in the chat box itself. Now I would invite Dr. Mwemba to kindly address the audience.
Thank you, Vardis. My name is Isaac Tausha, and I'm going to read the CEO's presentation word for word so that I don't miss anything. Maybe in case I will misquote me, but just to highlight that the COMESA Competition Commission, for those who might not be aware what it is, COMESA is the common market for Eastern and Southern Africa, which is an economic grouping of 21 member states in Southern, East, and Northern Africa and the Indian Ocean Islands. And it has the responsibility of encouraging economic integration. It also has the responsibility to enhance trade amongst the member states. And amongst the institutions that are meant to facilitate this process is the COMESA Competition Commission, which is represented here. And our main obligation is to ensure that there is reduction of anti-competitive practice that has got a cross-border effect. And amongst the issues that then we'll be looking at include those matters that have that affect two or more member states. So we look at competition, we look at consumer protection issues, and all the aim being to enhance economic integration, attract more investment into the region, ensure more employment and general economic growth. That is the responsibility of COMESA and the COMESA Competition Commission. And now to go into the speech, distinguished participants and colleagues, it is my great pleasure to welcome you to this COMESA Competition and Consumer Commission and CATS International organized webinar to commemorate the 2025 World Competition Day. Let me stop here. I think majority of you heard me saying COMESA Competition and Consumer Commission for the first time. Yes. The COMESA Competition Commission reviewed its regulations during the course of last year, and we can hasten to inform you that those revised regulations were approved yesterday to mark a new era, and it coincided with the World Competition Day. So there's a double celebration
Isaac,
here at the.
is it only me or I can't hear you? Is it just me or
I
others are also
think
facing some
think
trouble?
I'm able to
Sorry.
hear Varidhi. I think he's quite clear.
Yes. Maybe, Madam, can you hear me again?
Yes, we can hear you.
Okay.
Great.
We can hear you, sir.
Yes, yes. So I was mentioning that the COMESA Competition Commission reviewed regulations were approved yesterday by the COMESA Council of Ministers, and as a result of that, there is a change of the name of the organization from just COMESA Competition Commission to now COMESA Competition and Consumer Commission. So from Triple C, we are now Quadro C as an institution. So I thought it's just good to mention that. This day is significant because it reminds us of the vital role that competition plays in fostering efficiency, innovation, economic growth, and consumer welfare. Commemorating this day is not just a symbolic, it is a call to action for all stakeholders to adopt, nurture, and strengthen competition frameworks, institutions, and culture to ensure fair and competitive markets. World Competition Day serves as a global platform to raise awareness about the benefits of competition and the needs for robust enforcement of competition laws. It also provides the opportunity to reflect on emerging challenges and share best practices among jurisdictions. This is the reason why the COMESA Competition Commission joined the CATS International in lobbying for the recognition of 5th December as World Competition Day by the United Nations. I think Madam, when she was opening the session, she effectively highlighted what's the significance of the day being recognized by United Nations. I will elaborate a bit. Participants and colleagues, the recognition of the day, which is the 5th of December by the United Nations, would be a very important advocacy tool for all and in particular for the developing world. You know, our governments, when you look at them, sometimes you approach them on issues regards competition. It might not be given the ear that you deserve, but probably if it is a day that is recognized by UN, it will carry much more weight, and we believe that will be very helpful. It would elevate its importance globally, ensuring that competition policy receives the attention it deserves alongside other critical economic governance issues. COMESA has been actively advocating for the recognition, engaging with member states, the COMESA member states, international partners, and contributing to global discussions. COMESA, through its member states, submitted the proposal, which I think majority has already been highlighted by Madam, and up to the extent of the resolution that came out of June last year, IGE meeting and ANCTAD. So in this respect, this is a major milestone, that resolution that Madam read earlier on. And I wish to express our heartfelt gratitude to all the COMESA member states who have and continue to cooperate and collaborate in this endeavor. We would also like to thank all other UN member states that are supporting and lobbying for the recognition of the World Competition Day by the UN. Let me take this opportunity in furtherance of the need to have the day recognized by the UN to encourage all UN member states to pursue consultations and engage the United Nations through their missions in Geneva and New York to support this proposal of the recognition of 5th December as World Competition Day. Colleagues, let me explain a bit on this. This is very critical because UNCTAD actually advised us that it is the member states, particularly through their missions in Geneva and New York, that can advance this proposal. So the issue there now is for the missions to submit proposals, make justifications, ensure that there is a justified reasoning on why the day should be recognized. So we urge you all here as proponents, as colleagues in the competition world, to at every juncture, at every opportunity, engage our governments with this proposal so that they move the motion at UN as well. Now, turning to this year's theme, as we commemorate World Competition Day, which is artificial intelligence, consumers, and competition policy, I must say it could not have come at a better moment. AI is visibly transforming markets at an unprecedented pace around the globe, from personalized pricing to algorithmic decision making. AI is reshaping how business compete and how consumers interact with the markets. While AI offers immense opportunities for efficiency, innovation, and growth, it also has potential to raise serious competition and consumer protection concerns. Among the concerns that can arise include algorithmic collusion, where AI systems may facilitate tacit collusion without human intervention. And that will be a challenge to our traditional competition regulation methods. Concerns of market concentrations rising as a few tech giants dominate the control of AI infrastructure and data. Data is also becoming a barrier, i.e., access to large data sets is becoming a key competitive advantage, potentially excluding smaller players. Ultimately, consumer vulnerabilities are increasing, i.e., the risk of discriminatory pricing, opaque decision making, and privacy breaches. So, in this era of fast paced innovations, it is trite that regulation will always play catch up. However, competition and consumer protection authorities, economic regulators, and all stakeholders cannot fold their hands. It is our clarion call that there is a need to have a delicate balance of promoting competition and protecting consumers, at the same time encouraging investments and enhancing innovation. Thus, authorities and stakeholders, among other measures, may develop AI-specific guidelines for competition and consumer protection and enhance technical capacity to monitor algorithmic behavior, collaborate internationally to address cross-border AI challenges, and promote ethical AI practices that prioritize transparency and fairness. Colleagues, I do believe that the insights from the Competition Commission of India study, which I understand is going to be presented just now, uh, which will anchor today's discussions, will guide us on some of these matters. It will be important to appreciate how AI-driven pricing strategies affects market dynamics, the role of data in creating and reinforcing dominance, as well as policy interventions to ensure consumer trust and fair competition. It will also be important to understand the following. How can competition authorities detect and prevent algorithmic collusion effectively? Should access to data be regulated to prevent market foreclosure? And what safeguards are necessary to protect consumers from AI-driven discrimination? And finally, how can we collaborate globally to address AI-related competition issues? Let me hasten to highlight that COMESA is proud to announce that it has a new regulation freshly approved by the just ended COMESA Council of Ministers meeting. In the new regulations, the Commission has made significant provisions to address matters in the digital markets. Colleagues, in closing, let us use this occasion not only to celebrate World Competition Day, but to reaffirm our commitment to ensuring that technological progress serves consumers and markets fairly. Together, we can shape policies that harness AI's benefits while mitigating its risks. I thank you.
I think Varidhi is facing some technical glitches. So thank you, Isaac, and in proxying Dr. Mwemba. And I hope he's okay. And also congratulate you on being now 4C from 3C. So you will be able to foresee many things, I'm sure, in this. We'll just have a small ritual. We'll now proceed with a pre-release of ICRR 2025. ICRR is our flagship biennial publication. And this year's theme, as Varidhi has said, that it is maximizing AI gains and minimizing its risk. So can I request my team to just run a very few second video on this? Akshay, are you there?
Just a second, sir.
Okay. So there are chapters in it which has been contributed by few renowned writers in India. It is India specific, but I'm sure as it's technology related competition and regulatory issues, which can be useful for other jurisdictions as well. So with now, I hand over mic to Kazim to take the proceeding forward. Kazim, floor is yours.
Thank you, Ujjwal. I hope I'm audible.
Yes.
Great.
Clear.
So thank you all for joining in. Thank you, Cuts, for doing this much needed webinar. And the intersection of artificial intelligence and competition is getting more and more interesting. And with the advancement of AI and the sort of prolific use of AI tools, the impact and the application as well, this conversation merits a discussion. As you all know, that India's regulator, the Competition Commission of India, recently published its own study on understanding the intersection of AI and competition. And broadly, it was very clear that there are both pro and anti-competitive concerns indicatively, which have been highlighted. However, at the same time, we still are in a situation where there is limited to no evidence with respect to potential abuse or anti-competitive conducts across the AI supply chain. But having said that, I also just want to iterate the fact that the CCI study talks about a self-auditing mechanism and also talks about the fact that there has to be a presence of players across, the AI stack. Some of the other observations before I go to the panel is around the need for evidence-based enforcement. The fact that, the infrastructure players are playing a very important role in terms of helping startups and AI wrappers or companies which develop fine-tuned models on top of these infrastructure providers and large language models, and the fact that they are playing a very important role in the creation of this new industry and in sort of advancing business objectives across multiple jurisdictions, especially for India. Adopt AI, and as that adoption increases, you will see more and more intricate conversations and nuances which will be required to unpack this issue. So I would like to sort of begin this conversation having set this background, also having, the fact that we all understand that across the AI supply chain, you look at the compute, you have the infrastructure, you have data as a resource. Then you go to the model training and fine tuning of models, and eventually you have downstream applications which are used by the consumers at the B2C level and as well as enterprise AI at the B2B level. So this is the sort of larger broad supply chain which currently is in practice, and across these different verticals, there are potentially anti and pro-competitive conducts which might be discussed. So towards this, I'd like to sort of begin with our speakers, and maybe we could go to Odie, and if Odie, I could sort of ask you to, maybe you're already unmuted. Great. So would love to get your thoughts, Odie, in terms of, number one, if you're looking at the emerging economies, right, they are still building their digital regulatory infrastructure. So, what should be the core priorities which should drive the development of frameworks that govern AI market conduct? And would also love to get a sense from you. What are your observations in your jurisdiction globally, which you're studying right now, where you're looking at the AI supply chain very carefully? And what are the sort of competitive conducts you are witnessing? So, over to you.
Thanks very much, Kazim. It's a great pleasure to be here today. I'm just going to put this slide up. Yes, artificial intelligence is a topic and a market that is very new. And it was so valuable that you mentioned that to date there's not significant evidence of too much anti-competitive behavior taking place. Of course, we have the normal culprits that I would always argue is anti-competitive. For example, your algorithmic collusion, which is an issue. And also where particular firms are working on their own data, where they manage to harvest their own data, that they must definitely be able to keep that data and not basically lose that. And the third issue that I would say that competition authorities that are looking at in emerging economies would probably be the issue of bundling, so that companies can be able, not only horizontally, but also vertically be able to choose their own suppliers, that there's not an issue of lock-in. Having said that, and having considered the report of the Indian Competition Authority, I would like to highlight something that's very significant, and I think that's also critical for emerging economies to consider, is what's happening on the ground. Because it's very easy to move into a type of thinking where you believe that there are anti-competitive conduct, and we take our lead from handbooks, But often the handbook competition differs significantly from what we see on the ground in terms of competition. I've been in a very privileged position because I've been a professional all my life, and the past 6 years, well, some part of that has been retained, but we started Betweenity, and that is a business. So suddenly I came across this very interesting change in perception. What is the difference between what we see academically in terms of competition versus what do we see on the ground? If I can just quickly highlight this, because I think this is an excellent part of the market study that one doesn't often see in market studies. And that is the emphasis on the growth, literally at every level of the supply chain. And I'm going to err on the side of a little bit of an unconventional approach in focusing my response a lot on the issue of what is happening on the ground. If we look at the AI data layer, sorry, let me just quickly go back. We see in the Indian market, there are 11 significant players. Up in AWS, Google, Microsoft, Azure, Scale AI, IBM, Kaggle, Meta, Wipro, Playment. There are significant players, and these are some of the markets that are often argued are concentrated. According to the report, the AI layer in India is gaining traction. Startups started to enter the market post-2015 in response to increasing demand for trustworthy AI pipelines. So there was an issue regarding untrustworthy data, and there was entry. The diversity of offerings indicates a growth-oriented segment focused on AI readiness and governance by design principles. Very interesting, cloud computing is often seen as a very concentrated market. And according to the report, the players, there is Amazon, Microsoft, and Google Cloud, but other large established firms are Oracle, IBM, numerous of them. According to the report, this diverse ecosystem reflects the expanding market for scalable, secure, and innovative cloud solutions in India. I don't want to go through all of them, but I think let's quickly just look at semiconductors as well, because there is also a market that often gets an academic, that is on the negative side from an academic perspective, insofar as regulators believe that it is very concentrated, and that is the market of semiconductors, which is part of the cloud computing world. Between 2023 and 2024, there was a 20% increase in sales, and 3 large competitors in high-end semiconductors prevail. But as of May 2025, 6 chip fabrication units are under construction, with commitments from various players to boost semiconductor manufacturing. India is in the process of entering this market through a JV with a Taiwanese company. Micron Technology is a US company, and they will put up shop in India. This is the first time that will happen. According to the report, there's a growing set of startups that are entering the market, and innovation takes place across dimension of AI offerings. And we see, for example, DeepSeek that has just disrupted this market significantly with their very high efficiency GPUs. And there's already markets that are emulating this very high efficiency model. And in the interest of time, I'm not going to run through all of them, but this is literally the message that we get at every level of the supply chain. If I can just quickly to address your second part of the question, if we look at Africa's focus in relation to this particular market, and this is only in relation to the past 12 months, we can see in relation to the top market, South Africa was involved there in relation to a market inquiry and where the remedies specifically addressed issues regarding data. And then also in relation to the downstream market, the African Competition Forum has been involved in a digital market landscape study. 15 member countries in Africa participated in that. The Algeria Competition Council was involved in a predatory pricing case, which they dismissed because they said that there's not sufficient data of sufficiently long period of predation, including it's a new market. So that understanding is also there. The ECOWAS Competition Regulatory Authority conducted a digital market study. 12 West African member states have been involved in that. The Morocco Council settled with Glovo. That was in relation to a delivery app. Mozambique, they are conducting a study on taxi apps. South Africa, also it's the same study that I referred to above, that also has implications for the application level, and then also the online intermediation platforms market inquiry. So in relation to Africa, which is Betweenity's focus, there's definitely some kind of an overlap of issues that are being considered, even if it's not literally across the the supply chain. The focus in Africa is generally on digital. For example, Africa, Burundi, who's also on the call, COMESA, the EAC, ECOWAS, Egypt, Kenya, and Namibia, Mozambique as well. And then another major area of focus in Africa is also in relation to data prices. And in the past 12 months, countries that have been involved in that were basically the companies that we see here. So, Kazim, I'm going to stop there for purposes of this, just to emphasize that I think it's critical that we look at data on the ground and that we steer away from conceptions that because the handbook says something may be anti-competitive, that markets are constrained. Thanks.
Thank you, Odie. No, I agree. In fact, a few points I just want to bring in. One is market concentration. And I think this conversation and this point is reiterated in many such discussions. And, personally, and, as an organization, we do not agree that market concentration necessarily and always means market abuse, right? Just because there are a few select players doesn't mean that, the market is skewed towards those players or, there is anti-competitive conduct. So totally by that point. I think on the supply chain side of things, indicatively, what you've highlighted, I agree with that. There could be certain scenarios where we may witness anti-competitive conducts, and I'm using my words very carefully when we may is an important word because, as you said rightly, there is limited data. We are doing a study at the Dialogue. In fact, you will soon hear from us in a few months' time to understand what that data is, if there is any. And the point is to understand from a data point of view how these supply chain providers or the infrastructure providers or these hyperscalers are also contributing in a way pro-competitive conducts as well. So we're just trying to study what's the scenario pro and anti from a data point of view. Yes, I think also on the point of some sort of algorithmic collusion or bundling, but again, indicatives, even in the CCI study, it says that we are shying away from establishing theory of harm because there isn't any right now. And also the fact that market studies are usually done to understand and sort of look at indicativeness of where the market is moving. It's not necessarily looking at establishing theory of harm in the first place, because as you rightly said, it's a new industry, it's a new sector. So yeah, and I mean, I'll go to other panelists, would love to hear some pro-competitive conducts as well. But before that, I think I have to go back to Vidhi, because I think they have a short presentation on the CCI study. So Vidhi, over to you.
Yes, thank you. I will be presenting a short presentation on CCI's market study. If you could see my screen, please let me know.
We can.
Okay. So good afternoon, everyone. Today, I'll be presenting key insights from CCI's market study on artificial intelligence. This is a market study that maps India's AI ecosystem and its competitive dynamics. This presentation is meant to set a context for everyone here, for both Indian and international participants, so that we can approach the discussion with a clearer understanding and a shared starting point. CCI's market study basically consists of 5 key chapters, starting from how AI's ecosystem structure is to action plan for a more competitive AI ecosystem. For the purpose of this presentation, I will be touching upon the structure, application of AI in user industries, emerging competition law issues, and the proposed action plan. Moving on to the very first segment of the study, which talks about how AI ecosystem is structured. The market study labels the structure as an 8-layer stack, which can be broadly divided into two categories, an upstream category and a downstream category. The upstream layer is where the main infrastructure and core technology sits. It includes data that trains AI, the computing infrastructure required to run models, and the language and the development of technologies for machine learning, computer vision, and natural language processing. This is also the layer which includes foundational models, which are primarily developed by companies such as Google, Meta, Microsoft, and OpenAI. Coming to the downstream layer, this is where AI gets applied in the real world. It includes fine-tuning models for specific tasks, deploying them into product, and also the final interaction between users and AI.
Sorry. Sorry, Riddhi. Yeah, I think, there was some connection issue. Yeah,
No problem. I'll continue. So I was on the downstream layer. This is the layer where also us users, customers, and business users communicate with AI, and also business users use the foundational models in the downstream layer. Now moving on to the application of AI in user industries. The section of the market study highlights the pro-competitive potential of AI across various industries like retail, e-commerce, logistics and delivery, marketing, banking and financial institutions, and healthcare, among others. Organizations are primarily leveraging AI for customer engagement, virtual assistants, and personalized recommendation engines to enhance interaction and marketing strategy. Subsequently, technical applications such as supply chain management and dynamic pricing are also gaining traction. Across all these industries, AI adopters enjoy a very clear competitive advantage, including reduced operational costs, improved productivity, enhanced customer experience, and a more accurate forecasting. In the said chapter, the CCI's market study also highlights how AI's adoption is pro-competitive for MSMEs as well, helping them scale faster, reduce their cost, and helps them compete with the larger players as well. Now, as AI is being integrated into markets, new competition law issues are also beginning to surface. The CCI's market study identifies 6 major concerns. The first is algorithmic collusions. AI-driven pricing tools can monitor the market and adjust prices in real time. Self-learning algorithms, signaling, hub and spoke algorithms may independently align the prices across firms, creating a cartel-like situation without even human communication, which also makes detection extremely difficult. Landmark cases on algorithmic collusions like Poster Cartel, eTaurus were also cited in the market study. Now, second, price discrimination. Now, because AI profiles consumers and learns how much each person is willing to pay, it can offer different prices to different people. While this is also useful for targeted discounts, it can become an exploitative practice when consumers unknowingly pay more for the same product due to an opaque algorithm. Established firms, especially the dominant firms, have access to high quality data, advanced computing resources, skilled AI talent, and more substantial funding, which serve as an entry barrier for small and medium businesses or startups. Now, startups or MSMEs rely more on open source data sets. They face high cloud costs and struggle to secure capital, which also serves as an entry barrier and makes it harder for them to challenge the already established players. Now, predatory pricing was also a concern listed. Algorithms can selectively target vulnerable or price-sensitive users and offer them below-cost pricing to attract them to the product or the service, while keeping prices stable for other consumers. This micro-targeted form of predation allows dominant firms to exclude competitors much faster while also locking in the consumers due to the network effects it is creating. This leads to reduced transparency and reduced choice as well. Many AI models function on black boxes, where the firms and consumers cannot see how these rankings, recommendation, or pricing decisions are even made. This lack of clarity, combined with heavy dependence on dominant platforms, limits user choice, restricts visibility into alternatives, and can also stifle innovations. Big tech firms operating across multiple layers of the AI stack mentioned are increasingly acquiring or partnering up with startups or small businesses. While these deals can support innovation on one hand, they may also reduce competition by enabling an anti-competitive time. They can strengthen their dominance in already concentrated markets like AI chips or cloud, and also eliminate emerging rivals. This partnership could also lead to an exclusive or dependency creating partnership, which may foreclose access to essential resources or lock developers into one platform due to the high switching cost. Following the identification of competition concerns as stated, the market study moves on to the last chapter, suggesting an action plan on how to deal with the emerging competition law issues in the AI market. These include suggestions. The first and the most important suggestion was the self-audit framework for businesses. The self-audit framework is stated as a six-pillar framework, which would include governance obligations such as internal governance for AI competition compliance, design and development obligations like training data for fairness and biases, rigorous testing obligations, and continuous monitoring of AI deployed systems for transparency, and also documenting the same to keep records. Apart from that, the study also promotes CCI's advocacy initiatives, where CCI has proposed organizing AI and regulatory issues conference with stakeholders and conducting focused advocacy workshops on AI and competition compliance to raise awareness. Now, as data concentration has created an entry barriers and it is considered a major emerging competition issue as well. So to deal with the issue, initiatives have been promoted to remove the entry barriers, like promoting open source AI framework, increasing affordable computing access, and facilitating a wider data availability. Next, they are also suggesting increasing regulatory capacity, like establishing a dedicated think tank on digital markets to develop the expertise and provide insight into AI market, as this market is continuously changing over time. And the last recommendation that has been provided was interregulatory and international cooperation. To promote interregulatory cooperation with the domestic regulators, MOUs should be made, and to collaborate with international authorities through bilateral agreements and multilateral platforms in order to facilitate the cross-border cooperation and stay aligned with the global best practices in addressing the AI-related competition challenges. Taken together, these recommendations present a forward-looking approach, which is not to restrict AI, but to guide its growth in a way that supports competition, encourages innovation, and also keeps the market open for small players. With this, I conclude my presentation. Thank you all for listening.
Thank you. Thank you so much, Vidhi. I think you sort of covered everything from the report. And I think you spoke about a few important anti-competitive conducts, from AI collusion to algorithmic collusion, sorry, to price discrimination, entry barriers, predatory pricing, reduced choices, etc. So, of course, I think just to reiterate what I had said earlier, the fact that all these or most of these are indicative in nature and have been outlined in the study. But I think the writers themselves, I think CCI has acknowledged the fact that there is no evidence to suggest that some of these or most of these anti-competitive practices are taking place. And I think on bundling as well, there have been conversations around, AI platforms, getting into deals and leveraging. But I think it's also important to understand that we are at a very nascent stage where access to the technology is limited. And I think it's important to also ensure that you are able to expand the use as much as possible. And from an industrial point of view, I think that's what the companies would want to do. And for consumers, I think you had already highlighted how it's helping them across various use cases as well as businesses. So I'd like to come now to maybe Rahul, if Rahul could. As I think Rahul is here, he could unmute himself. So Rahul, great segue to what I wanted to ask you was on your views on the study on competition and AI, right? I think we've spoken at length about this in the past, but do you see where we are currently in the regulatory side of things? We are well protected, and regulatory wise, any potential anti-competitive conduct would be taken care of through the current legislation and the regulation we have. And what's your take on the study at large? Do you agree with the findings? And because the AI world and the industry is moving quite fast, I think these things will evolve quite quickly in the next 2 to 3 years. So we'll love to get your thoughts on that.
Thank you, Kazim, and thank you, Kutz, and all the participants for joining us for this discussion. Let me take your second question first. Always start with the easier one. We can't but admire the Commission's work in taking the initiative to conduct this study. We have to see this study from the lens of an attempt by the regulator to understand the lay of the land. If we look at this study from the lens that does it seek to find areas for intervention, then that's perhaps the wrong way of looking at it. We are at a stage where we are all trying to understand what is going on. And by the time we understand one layer, there's something else that crops up and our understanding needs to be updated. So if we look at this study as the first step by the regulator to help not just themselves equip about the nuances of how AI is developing, the various stacks around the artificial intelligence and the routes to get to the market, then that's half the battle won for antitrust enforcement. And I go back in history to the earliest era of Microsoft. And that's when they developed the idea of how to take a software product to end users. And the route to market for them was tie-ups with various other technology firms. And that's perhaps going to repeat, or it is already repeating in the world of artificial intelligence. Now, in the Microsoft era, the route to market was not paved by Microsoft itself. But what we need to be watchful of is the fact that the route to market for taking any one of the products around artificial intelligence, starting from foundational models down to the application layer, the routes are paved by some of the large technology firms. And at each juncture, those large technology firms have their own flag posts. And when those flag posts collide with competitors' offerings, there will be friction in the market. And how does the regulator spot those instances of friction? How does the regulator intervene to remedy those interventions? Those instances would be interesting for all of us to watch. So the study does a good job. It helps us understand where the potential focus could be. If I may add, and only because things are changing this dramatically and so fast, one of the areas where I hope that the Commission does more work, or at least there are two areas where I hope that the Commission does more work. It's great to understand the entire AI stack, but in a world where agentic AI replaces human interface to engage with the online economy, will create a lot of frictions. We have already seen a suit being filed in United States. Amazon is taking one of the agentic AI tool providers to the court. That battle is being fought around privacy rules and data access rules. But it raises a very important question in the world of antitrust, which is that, is there a duty to deal for people who today manage the web of online interactions? And those online interactions get managed through the applications that these companies have created, but ultimately there's a human being who decides what shirt to buy or what groceries to order. But tomorrow, when agents replace human beings, the economy built around advertising will crumble. And therefore, there is going to be a huge flashpoint commercially between two poles of the AI world, and we don't have clear answers. So I would hope that we build upon this study to understand that interface a little bit more.
Thank
I'll
you.
pause here on your first question. And in the enthusiasm to answer this one, I've probably exceeded the time limit. So if it's okay, I'm going to skip. And if it's not, then I'll request you to repeat the question.
Yeah, no, very quickly, Rahul, if you can. I wanted to understand the current regulatory capacity of India. Do you see that sufficient enough to deal with potential anti-competitive conducts in the future in the AI supply chain space? And maybe even, I don't want to go as far as agentic AI, but I want to stick to what we know of today. So in the AI supply chain, do you think we have enough regulatory muscle to deal with any future harms?
So let me answer this question in twofold. The human resource capability, just in terms of sheer numbers, we do not have enough people within the organization, within the regulator. And that's a constant request that we have made to the government from different fora, that please bring more people on board on the regulator side. In terms of their own internal capacity development, this study is an example. The regulator is alive to this area, and they're trying to equip themselves to understand the issues better. The third part is our law itself geared towards addressing the concerns that may crop up in the world of artificial intelligence and their usages, various use cases? I think we are pretty much there. It's a very principle-based legislation, has sufficient flexibility built in.
Yeah.
And therefore, we will have the ability to interpret the law and apply the law in a way that the harms from at different junctures that I spoke about are adequately addressed. One gap, though, if I may point out, is around self-learning algorithms, which can potentially facilitate collusion. Our law got amended in 2024, specifically the provision on cartels got amended to introduce the word intent. But in the world of self-learning algorithms, which can potentially facilitate collusion, lawyers and policymakers, OECD has done a lot of work in this direction, have been questioning the fact that is intent the right legal tool, or is intent going to be sufficient to address the question of self-learning algorithmic collusion? That's one. And two, how do we attribute liability? These are two open legal questions. There are some creative solutions which are being thought about. OECD suggests that from the traditional meeting of minds thresholds in collusion, we should move in the direction of what they call foreseeability or controllability. That is the key management able to foresee the end result that self-learning algorithms will lead to when they are onboarding those tools. And if they're able to foresee, then should there be liability? Or if they're able to control, then there should be a liability. So these are questions which are being debated. Is there a need for us to shift from the traditional construct of meeting of minds, which was anyway difficult to prove in the physical, in the world of physical goods and services? From there, we move to intent, as has happened in our legislation. But could we move in the direction of forcibility and controllability to attribute liability? Interesting questions. For a change, lawyers are trying to innovate. We have never innovated. So let's see where we land.
Great. Thanks. Thanks a lot, Rahul. Quite detailed on that. I'll come to Leonard. And Leonard, I think you can switch on your camera. You can maybe unmute yourself. Thanks a lot, Leonard. You're a member of the ECOWAS Regional Competition Authority. Pleasure to have you talk to us. So would love to get your thoughts, Leonard, on the ECOWAS region's view on the intersection of AI and competition, right? And also the fact that AI adoption is taking place. How do you see the interlinkages between adoption and potential anti-competitive conducts? And also, what are the sort of main or primary consumer protection risks which are associated with AI, which appear most acute, in the West African region? So would love to get your thoughts.
Okay, thank you, Kazim. Let me start by stating that, yes, I'm a member of the ECOWAS General Competition Authority, but I'm not today speaking officially on behalf of the ECOWAS Regional Competition Authority. So whatever I say is on my personal capacity as a competition and consumer protection law expert. Okay, so having said that, let me start by commending the approach of the Competition Commission of India in undertaking a market study on the AI market. I think I've been one of the strong advocates of having a market study approach when a competition authority is entering into a new technology space. And we'll see that the advantage of that is that the competition authority is able to understand properly how that market operates within its context, because that's usually the problem. The challenges or the opportunities of AI in Europe or in the US cannot be the same for an African country, for example. And here we have specific issues that we need to address. Unfortunately, there is not a lot of attention paid to AI. Yeah, some of the national competition authorities are trying to catch up with the general technology regulatory space. And now we have to deal with AI. And one thing you see is that we have regulatory frameworks that are not properly suited to address emerging technologies. That's the number one problem. And then the question is whether we need tailor-made laws or rules for the AI age, or whether we need to continue and adapt what we have to solve the emerging problems of AI. Some of the issues that we should be looking at as a region. Now we don't control the compute power. So in terms of the upstream, the chips, the technology that drive AI, we don't control that. But in terms of the talent that drives AI, we have some competitive advantage in that space. So one of the things we should be looking at is how the talents and also the data set that drives training. Now, what we should be looking at is how do we then deploy the data set we have and the talent that we have to insert ourselves into the global AI value chain. And let me zero in on data set a bit and make a comparison between that and the first industrial revolution. Now, Africa has been historically a supplier of cheap natural resources and cheap labor for industrial manufacturing or productivity in the West, and then we are net recipients of the final product. Now, you see that same pattern repeating here, where data is being mined from Africa, both from publishers, from content creators and all that, and nobody is even paying attention to the fact that this data is being mined. And we're not talking about the copyright implications. We're not talking about equitable access to this data. So because we are all hooked up to this global online system driven by the Googles, the Meta, Facebook, who are all there, and this data is being mined at scale and being used to train foundation models. Now, what is our stake there? What are we getting in return? We're only getting the finished products. So the consumer-facing ChatGPT and Copilot and that. And the more we use, the more we're reinforcing the capacities of this without receiving anything in return. And so what we should begin to ask, how do we then insert ourselves into this market and begin to claim advantage? And that's where regulation comes in. Can we consider rules or regulations that at least transfer some of these profits to our local publishers, to our local talents? That's number one. The number two, in terms of the talent, I think Africa needs to be more, would I say, strict, probably more careful would be the right word, in supporting local talents that want to plug into the global AI ecosystem. Look at the example of was the new AI from China. I can't remember their name immediately. Now, they more like upset the market by bringing out a model that was far cheaper than what the Western world, like the US tech companies, have used to build their own system. Now, this emerged from probably, say unlikely, because we're all looking at the US companies, and then suddenly this springs up from there. Now, what do we need to do to ensure that we have innovators in Africa who can spring this kind of surprise? Now, we then need to go back to infrastructure, basic infrastructure, data computing power, broadband infrastructure. We need to go back to basic digital literacy and then upscale. We have the human resource. So if we invest more in developing the capacity, the digital literacy, advanced computing capability in our teeming young population, then we stand a chance, to get plugged into this global ecosystem. Yes. So do I have more time to continue?
No, Leonard, in fact, I could maybe give you 2 more minutes, but I have a question as well.
Okay.
And this is a question for everyone, and we understand that, there will be certain regions who are more consumers of the technology than creators of the technology, right? And obviously, the more downstream you are, the less leveraging power you have, right? I mean, that's natural.
Definitely.
Now, to this point, and to all the panelists, I have this question, including panelists from India, is will competition law solve the problem of technology, right? The question being that what we don't have, what we don't create, can competition law bring in a level playing field with the context that is there an uneven playing field, right? I mean, if you look at China, China doesn't require a legal method to compete with the large American companies. I think they have built DeepSeek, and there are other companies which are competing equally or maybe stronger than most of of the large big tech platforms, right? So they are at that level because they've been able to innovate and build that technology. So I want to leave that thought with all of you, and maybe Leonard would love to get your thoughts on this in terms of how will competition policy help in, removing some of the dominance or maybe limiting some of the dominance effect.
Yes, thank you, Kazim. I think competition law can help, but what competition law can do is limited. In our own context, without industrial policy, competition law would have limited impact. So what I mean by here, so competition law can help to make sure that the market is contestable. So in the upstream, in terms of access to data, in terms of control of computing power. And interestingly, we can draw also a historical parallel with the evolution of the tech industry in the US. So if you recall the AT&T case about the control in the telecommunications sector and how AT&T was barred from the emerging computer market, and how that then encouraged other companies to invest in that market and to innovate. Now take that to the IBM bundling of software and hardware, and how the antitrust settlement, led to the development of the independent software market. Same happened between Microsoft and the emergence of Google. So when Microsoft was also barred from bundling the hardware with the Internet Explorer, that led to the emergence of the likes of Google's and the Mozilla's and the rest. Yes, so competition law can play a very important role in making sure that the market is contestable by limiting the capacity of dominant players to leverage their dominance into an adjoining or adjacent market. So that's a solution. But that happens under the presumption that there is a latent innovative capacity. So in this case, if we bring in, if we limit the power of dominant firms, so companies in the UK, in the European Union, in the US can take advantage and develop. But it remains an important question. Without the capacity, can antitrust alone, can competition law alone help Africa? It's doubtful whether that alone can work. So we need specific industrial policy to develop capacity, from infrastructure to human capacity to be able to compete effectively.
No, absolutely, Leonard. In fact, I totally agree. I think domestic capacity is critical to compete, right? I think if you can build the supply chain, and if Africa can sort of move in that direction, I think all of us are trying to move in that direction. In India, we have a very robust program called the India AI Mission, which is $1.4 billion, I think, if I'm not wrong, somewhere around that figure, to build local compute, to build local models. And we already are working towards our first foundation model, which hopefully will be launched early next year or sometime in Q2 of next year, which will hopefully provide infrastructure or the base for startups to then innovate on top of it. So we understand and we recognize, global South countries, that regulatory tools are not enough. I think regulatory tools will only aid or support your mission towards bringing more competition. But I think at the end of the day, domestic capacity has to be built from ground up. And this is where I feel European Union is quite laggard right now. And that shows in the lack of tech startups in Europe, and the fact that they had to resort to an ex-ante approach to deal with some of those problems, which are now becoming counterproductive, because the European consumers are facing a lot of issues when it comes to the ability to use products in their jurisdiction. So I think that's an important lesson for all global South jurisdictions, is not to go in that EU direction, is to sort of focus on local capacity as a counter, as an alternative to the large companies, and then provide that regulatory enablement for all the industries to compete, right? So totally by that point, I'd like to come to Hemangini, who's been very patiently listening and waiting. And thank you so much, Hemangini, for listening in. And I think, the advantage of being the final speaker in any webinar is you have the best context, right? So think of it as, you have the best LLM and now you can innovate and build on top of it. So I'm sure your points will also be equally nuanced, but I think would love to get your thought, Hemangini, on, of course, all the discussion we've had till now in terms of the Global South approach and the Indian approach to regulation, and of course, the CCI study. But would also love to understand from you, what are the global enforcement trends you are witnessing, which are shaping expectation for companies operating in India with significant AI reliance in their business models, right? So would love to get your thoughts.
No, thanks, Kazim, and truly fascinating discussion, and thanks to the CIRC team for having me. I mean, I think this topic is one where every nuance has a nuance. So it's difficult. I think we're still at the stage of trying to understand the various AI stacks, the fact that each one of them overlap with one another, that each one of them have distinct functions which we're only scratching the top of, makes it all the more complicated. But maybe to just start with the CCI's endeavor to begin the process of understanding. I think it's a very timely market study. I think the objective which it set out to do, like Rahul mentioned, and fully agree. I think the fact that we're trying to understand the AI stack, the inputs, the resources, but equally to understand where the potential problems could arise is a great step. It's the right step to take at the right time. And I think the outcome also reflects that very objective. In order, I think there's a lot of discourse, and maybe this is coming from all of the sort of conversations, discussions, and debates that we've had, just previous to AI, was regulating digital markets when it came to big tech. And recently, of course, the government has also sort of considered, after with our own law having the Indian version of the DMA, as it were, when it was going to the draft that had been
The
circulated,
DCB, you mean?
the Digital Competition Bill. I think the government has also recognized that we didn't have enough evidentiary or evidence to come up with the kind of strict ex ante obligations that were going to be sought to be implemented under the draft law. And so now we're looking to see whether we have that, and whether such provisions can be more justified, because the implications of introducing an ex ante law will be significant, and it has the ability to stop innovation. And the entire discussion is to make sure that innovation is not hampered. We need to protect various players across various levels of the competition, but at the same time we want to preserve competition, and that's a really tall ask. And the very first step is to understand exactly how this works. And I would think, and when it comes to AI, it's a lot more complicated. At least with digital markets, you're looking at a set of markets. Yes, there are two sides to a market, but that's still one market, one or two sets of players or three sets of players that we're looking at. When it comes to AI, there is no one market that you can sort of consider in isolation from all the others, which are entirely dependent. So where does your cloud end? Where does, or rather, which part of the infrastructure in AI are you really concerned with? Only cloud, only GPUs, data, which is its own set. Which type of data? We're looking at pre-training data, what's called correctional data, or training data, and then finally application data. So there's just so much information out there. I feel that as a very first step, before we start with the discourse on there is market power, of course there will be market power when there's this kind, or I won't say even market power. I think the AI infrastructure requires a lot of investment. the natural first movers in this market would be those who are already using some of those infrastructural tools to provide the precursor to what we have in the AI market today, as it were, in digital market. So it's not to say that we need to start immediately, to put it a little, bluntly, to start fretting about how to regulate this market. Let's try and understand what this market is first. Let's try and understand each, whether there is intervention required in each stack or not, and frankly, whether intervention in each stack is something that we ought to be doing, or we should be looking at it as a whole. And again, market power in and of itself cannot be a concern. We need to look at whether there is conduct, and that conduct is going to jeopardize competition. We're not even looking at, for example, the AI Act that Europe has introduced is looking at it from a very user consumer centric purpose. And when you're talking about competition policy, it's about, ensuring, or rather the underpinning of competition policy is if you have enough competition, users will benefit. And we really need to question whether, do we need perfect competition at every stack? Is that even desirable? Is that even something that can be done in this market? Because when this law was drafted, I don't think, or when the principles of competition law, which continue to be relevant today, have 100 years old. No one had even imagined, the world that we live in today. And so, it's to just extrapolate those principles and try and put it down here and say, okay, if we don't have perfect competition, or we don't have, 100 options to choose from in every stack, that in and of itself is a problem. One really needs to consider whether that's the case. The fact that AI has, significant advantages, I don't think anyone is questioning that. And the key problems that everyone is concerned with in AI has got to do with the application of AI. I think let's wait and see where, at least for where competition, whether we have enough competition. We've already seen disruptors in stack, in various, for example, DeepSeek using, Huawei chips instead of trying to reduce its reliance on NVIDIA, and doing well with that. And India AI mission is coming up with our own Bharat Gen, which is coming up with a very ambitious 22 language AI model, which will try and offer the Indian give a leg up to the indigenous AI race, as it were. So I think there's just too many moving parts right now. I think all we can do is discuss, all we can do is try and understand this better. And I think this is probably the one area where we probably need more inputs from our engineers, from our technical experts, to be a lot more, I think, active before we start to regulate. I think we really need to understand this a lot better before we try to come up with, first even identify whether we need solutions at this point.
No, I think I totally agree, Hemangini. In fact, the point on bringing in more technical experts who understand how models work and what goes at the back end is critical to sort of informing any regulatory amendments in the future. So very well taken. And in fact, I just want to add one point. If you're looking at the supply chain, the AI supply chain and the hyperscalers, and, there has been a lot public conversation whether hyperscalers enjoy a greater dominance, and are they limiting competition because of across the AI supply chain from to downstream application. Well, you look at the rise of ChatGPT, and I don't know if anybody knew about ChatGPT before it was launched, and for quite some time. And I mean, arguably one of the best models, people can argue it's the best model, right? I mean, we don't know. But if you look at the legacy companies like Google's of the world and others, I mean, if there was no competition, then, they would have been, their models would be far, far outperforming what OpenAI is able to produce, right? So I think the point is that within the AI, generative AI and the AI landscape, there is enough competition itself, right? The fact that you can build a DeepSeek in 2025, and it's sort of beating the many other American players in the benchmarking test, despite having lesser compute access. So these are very clear indicators that presently, the level of competition within the AI supply chain and within the AI market is quite intense. You have new models emerging. A lot depends on how well your algorithms are designed. A lot depends on how well you're able to structure and compute the data sets which you have. For a market like India and for the linguistic diversity which we have, American data sets won't work. So models have to reinvent the wheel and sort of compete locally and make that happen. So I think, the tables are sort of totally different when it comes to India. And of course, the advantage which many Indian developers would have is the ability to understand and relate to the language diversity, right? I think that's something which also must be discussed, and the fact that it's not an easy competitive field. Just because you had an hyperscaler, you can come into a market and become a dominant player. That's not set in stone. We've seen, companies like OpenAI, others are able to compete and outperform a lot of these large big tech companies as well. So thank you, Hemangini. I just want to sort of run back to Ujjwal and just check how much time do we have, because I think it's 4:30 was the ending time. We have 10 minutes, Ujjwal. So do we take
Yes.
any more
Yeah,
inputs?
we should take questions from audience.
Okay.
And,
Great.
there was
So why
question,
don't we?
there was one question in my private box, but I think that
Yes.
has been answered already by Rahul. This was regarding
Right.
algorithm tacit collusion and what changes in approach was required. I think Rahul has. But I have a question. I mean, there are talk about sovereign AI is getting traction, and I understand from South Africa, Nigeria, India also
Right.
there is a talk about sovereign AI. So what competition policy role can play towards sovereign AI to happen?
Who wants to take that up?
I see Odie raising hand. So
maybe, I don't know. Rahul, would you want to take that? Oh, okay. Odie has already raised her hand, so maybe we can go to Odie. Yeah.
Sorry, yes, I raised my hand in relation to one of the other aspects that were done. Maybe, Ujjwal, if you can just explain what exactly you mean with sovereign AI in the context of the discussion.
This is typical geopolitical question that AI is a tool to kind of new imperialism. We are getting into a new imperialism phase, so we should have some sort of national foundational AI. Many countries are thinking, like China has a DeepSeek and things like that.
Yes.
So if governments wants, in fact, governments want, but there may be constraints. So in that sense, is there a role for competition policy? That's what's my.
Yeah, that's a very good question. Something
but
that
you can
struck
also answer, take the question that you wanted to answer.
Right, thanks. Just something that struck me this week, and maybe it's not a complete answer, but the fact that the US government said that they would like to, they will allow NVIDIA to supply chips to China on the basis that they will get a kickback. I think it's 10%. And that was completely contrary to what I would have expected. And it is just fascinating to see how that dynamic is playing out. So yeah, probably for sure I would have to think in terms of a competition authority's role there, and probably there is not a role, not at this point, just to let the market happen. And I'm mindful of our previous, I think it was Hemangini who mentioned that we must wait and see at this point. And I also want to add, and I think this also contributes to your question, is we must enjoy what we are seeing, because this is literally a market that is so competitive and dynamic, and I am sometimes a little bit worried, and I'm not sure whether it's anxiety by the competition authorities, because they missed the boat on digital. Now they want to be extremely in time for everything else. But I'm not sure whether one should be so extremely focused on the regulation. And it's also not the task of competition law, I would think, to create competition. If you want to create competition, then have a very proper, strong entrepreneurship policy and make sure that from primary school and high school you get proper training on how to raise capital, how to run a business, so that you can fail, and you fail when you are young and the stakes aren't high. But for a law to come and want to protect players when people are 35 years old and for the first time they want to venture into a market, I don't think that's necessarily the right thing to do. What I would love to see is that competition authorities not only employ the lawyers and judges, but founders, even if it's so that they can start to get an appreciation for what is competition on the merits. And how does that look? They start to move away from competition that they learn in handbooks and want to impose a little strand of information that they see out there in the realm. And just something interesting that I was thinking when I read the report of the CCI on the barriers to entry. Something that I wondered was, how were these barriers identified? What exactly were the questions posed to the people who answered the questions? For example, were the barriers already listed, and were they only required to rank them? Because if you are going to work on that basis, it's basically the competition authority's answers. And you start to solve a market for data and for infrastructure. Well, that's not actually what's happening. Should that answers not be taken to the founders who managed to enter the market regardless of those barriers, to verify that and to get an indication of how did they manage to do that? Because the moment that you start to understand how those founders started to make the breakthrough, you start to see that there's this whole new way of doing things, and you start to get a better appreciation for the competitive process and for how dynamic it is and for how experimental it is. And I think that is critical. I think the game changer, especially in relation to Africa, and I don't think it will happen, but I'm putting it on the record, is if there could be more business people involved in competition authorities. Because at the moment, and we see this in South Africa, cases are being taken to the competition tribunal on matters that the competition authority thinks constitutes a hardcore cartel, which is actually so pro-competitive, and there's a complete mismatch there. So I think that would be my first choice, that there's a deeper appreciation for business and for competition on the merits, which I don't think is currently the case. Sorry, Ishwal, I don't think I completely responded to your question.
I think you have already, yeah. Over to Kazim. Kazim, I think we can extend it by 10, 15.
Yeah, I think Hemangini and Leonard, maybe Leonard can also come in.
Yes, that question about digital AI sovereignty is an important one, and I alluded to it somehow in my intervention. But let me say more about it. So you can use competition law to ensure that the market is contestable. So you can use structural remedies, for example, to limit the scope of how existing dominant firms can use their power to leverage into the AI market. So that's competition law there for you. Now, but if you don't have the latent innovative capability to then take advantage of that market, then you're not going anywhere. I'll give you the example of the European Union. So the European Union has made great advances in regulation, but that has not helped to tilt the market in favor of the European Union in a way. Now what is happening, if you follow the debate around the Draghi report on European competitiveness, Europe is now taking an explicit industrial policy approach towards building European tech industry. So what you're going to be seeing is a lot of investment in different layers, from infrastructure, from to capacity, to human capacity and all that. But more importantly, the an element of it that is interesting is the move to use public procurement, to build an EU tech industry. So what that means is that giving marginal preferences to EU tech as opposed to American tech or Chinese tech and all that. So the answer is that if you're looking at digital or AI sovereignty, competition law is not enough. In fact, you could say it's a poor tool. It can take you only so far. You need specific targeted industrial policy measures and public sector investment to be able to attain digital sovereignty or get close to digital sovereignty. Thank you.
Thank you. I think, Rahul, would you like to come in?
If I may, and thank you, Kazim. So let me try and deconstruct Ujjwal's question as a competition law practitioner. I'm assuming, Ujjwal, that when you say sovereign AI, you're talking about large language models, right? What do we need to create large language models? It's a layered stack of requirements: data, compute, technical expertise, and then comes the model development. And once you have developed the model, then it's about the downstream distribution. Right? Let's take each sequentially. Almost all large language models have been built on data which is publicly available. So it's not really a significant barrier to entry. When large language models have accessed proprietary data, take for example from publishers, the developers have entered into partnerships to access that data. Now, publicly available data, there is no need for any intervention. If a data repository, for example, a publisher, agrees to engage in a partnership with company A, but refuses to do that with company B, which is an Indian company, for no justifiable commercial reasons, then that's potentially an anti-competitive occasion, and that's potentially an occasion for the law to intervene and try and remedy that situation. So this is one example at the data layer. Let's go to compute layer. Today, at least in India and globally, compute is being made available through cloud service providers for large language model developers. Each one of the large cloud service providers have already committed to invest billions of dollars in India in data capacity. They are all looking at India as the market where they sell their compute power. So access to compute is something which is not insurmountable. In fact, it's easily available for Indian developers. Yet at the layer of compute, when it is being accessed through cloud service providers, it will be useful for, in the event that the egress from one cloud service provider to the other is made more difficult by the incumbent, then could that be an instance of an antitrust scrutiny, at least, if not an intervention? Answer is yes. And if that egress cost is too high, if the ability of the customer who is on a particular cloud and is taking those services is restrained for a long enough time without any real strong underlying commercial justification, then there is a possible role for an antitrust regulator there. Then we come to technical expertise. There's nothing that anyone can do apart from trying to entice the hordes of Indian engineers who are building these large language models sitting in Silicon Valley. Not the antitrust regulator's job, it is the job of the country as a whole. We need to create the situation good enough for them to come back to the country. Then we get to model development. If you have talent, then we'll be able to develop the model. There are already non-proprietary models available in the market, open source models available in the market. Indian technology experts, engineers are spread across each one of these large companies which are developing these models. So it's about creating the environment in India to bring them back home. Then we get to the downstream distribution stage. What use is the large language model unless we can take them to the end users? And this is where there will be the occasion for a lot of friction, or there can be the occasion for a lot of friction, because each of the large cloud service providers have their own models to offer. But I must say here, it is so heartening to see, led by Mr. Satya Nadella a few months ago, in an interview, he said, and these are lessons learned by Microsoft because of decades of antitrust scrutiny, that we do not want to inhibit the distribution of any large language model. Whoever wants to come onto our platform, we will facilitate that distribution. The UK Competition and Markets Authority has done a fairly good study on AI and potential antitrust issues. And they identify that Satya Nadella's statement is true across every single large cloud service provider. So none of them today inhibit the ability of other competing large language models to be distributed through their cloud. But there can be, if we see friction there amongst the channels of distribution, which create roadblocks for an Indian large language model to reach the end consumer, then there is again a potential role for the antitrust regulator. So if we split it up at each layer, apart from the layer of technical expertise and model development, there is a potential role, but that potential role kicks in only when we see either an incumbent creating a barrier to entry or raising the cost of doing business for the new entrant providing large language models.
Thank you,
Rahul.
Thank you.
Maybe Hemangini had a point.
Yeah.
So
I'll
maybe
just
that.
take 2 minutes. I think, to your question, Ujjwal, which was, what is the role of AI sovereignty over here? And if that means that we need to have, in an effort to ensure that, and I think this was a point made by Leonard also, is that when Indian users give their data, which is then one of the key inputs that we need for AI ecosystems to flourish and to retain that in India, if by AI sovereignty we mean that we need to have an Indian indigenous entity at each layer of the AI substack, and what is our view from a competition law policy, I would imagine that, I think for a free market like ours that India has at this point, I think it's good to enable options, and where we feel that there may not be enough options to enable that kind of competitiveness in each of those stacks, perhaps the government could come in to complete that void, as it were. Right now, for example, when Rahul did mention that data, it is all publicly available, and that's entirely correct, but it's the access to that data that continues to be the challenge. Data is certainly out there, but how does one access it enough to train your various models on it? And again, the government over here is the largest repository of data, can really step in for that to enable the kind of indigenous competitiveness that we want to promote. But to say that for this, because we want to make sure that all the data, like our data, is used and is the data of Indians is used to further sort of Indian good, I don't know whether that translates necessarily, but I think we certainly need, or the government's role here will be to make sure to identify the voids that is stopping sort of business from flourishing in India, and really try and fill those in wherever it can. So for certainly when it comes to providing the data, which is maybe not available entirely, I think sourcing or creating or using its funds to come up to with alternatives. I don't know how possible that will be for coming up with chips that can compete with the likes of Nvidias and AMDs that have been doing this for a very, very long time. But certainly, I mean, it's not off the table. So I think investment and identifying where they can step in rather than trying to just simply promote indigenous industries in order to achieve sovereignty in AI to do it.
If I may just be a little more generous to the Indian government, we are making those efforts. We have a framework for sharing of data that the government today has with it. The government has come out with a clear framework for sharing of non-personal data available with the government. They didn't transplant those requirements on the private enterprises, but that's a thinking in the right direction. And as Hemangini pointed out, these initiatives need to increase, and they need to focus on each layer of the requirement to develop in a nice way, as Ujjwal you put it, a sovereign AI, but essentially a Desi LLM.
Yes, thank you. Kazim?
Thank you so much, Rahul. Ujjwal ji, I think any sort of final remarks from your side? Would love to get your thoughts as well.
I have two takeaways and one request. That is, as far as the anti-competitive issues in whatever has been reported, I think India and many other countries which have studied their digital markets are around, kind of at par now to, kind of intervene when the need arises. So, except for the capacity of the regulator, that may be a problematic. Otherwise, understanding wise, I think we have better understanding in the developing world as well. So that is one takeaway. So nothing more to worry about, that, again, it will be very anti-competitive market, though concentration is there and concentration can be beat what Leonard by industrial policy, applying industrial policy better. That is my second takeaway, that the countries should emphasize the industrial policies, their national industrial policies, because of the geopolitics that has arisen today, began with US-China trade war and now has, kind of snowballed into many other regions and things like that. And we talk about now geopolitics is guiding many things, including norms and the behavior, countries' behavior, industrial policies as well. And third is the request for everybody, all the participants and all the speakers, to please sensitize your government's representative and relevant departments to get the World Competition Day, 5th December, to be adopted at the UN level. I think we have enough critical mass of that support now, but that need to change into reality. The competition forum is sensitized, but I think the competition people need to sensitize the one, either PMO or their nodal ministries to intervene at the UN level, because competition authority do not have that power to do that. It has to be a government representative. So this is the request, and I take this opportunity to thank everybody, speakers. I first thank COMESA, Competition and Consumer Commission, 4C, in absentia Dr. Willard Mwemba, who was proxied by Isaac Toso. Isaac is a chief economist of 4C. And I thank you, Kazim for being a moderator, a very good moderator.
Thank you.
And thank all the speakers, Odie, Rahul, Leo, and Hemangini, and all the participants. I hope you all have benefited from this. The slides will be uploaded, and request Odie to please send your slides so that we can upload that also for the participants' benefit. So thank you very much, and wish you all happy World Competition Day. Thank you.
Thank you.
Thank you, everyone.
Thanks very much. Thank you, Ishbal, Kazim.
Thank you so much.
Thank you, everyone.
Thank you, Leo.